Thank you for listening to this PYA webinar recast. PYA is pleased to offer this alternative way to access our thought leadership. This is a recording of a previously delivered webinar. The information is accurate as of the date of the original event. The video recording, slides, and associated material for this and all PYA webinars are available on our website at pyapc.com. This podcast is for educational purposes only. It is not intended to be used as legal advice or an official opinion.
Hello, and welcome to the 7th annual Let's Talk Compliance Conference, which is co-hosted by Foley and Lardner and PYA. I'm Jana Kolarik, a partner in Foley's Healthcare Practice Group, and this is my co-host, Angie Caldwell, consulting principal at PYA.
Like Jana said, this is our second session of today. We have 2 more tomorrow, so please bear with us for a moment as we have different attendees at our sessions, but we just want to play. I want to play historian a little bit and recognize the 7 years of this conference and the partnership between PYA and Foley to put on this conference every year. Thank you guys so much. Thanks to our wonderful presenters today. And thanks to all of our attendees. We have increased in registrations and attendees every year across the 7. Hundreds of attendees from all types of different healthcare organizations all over the country attend this event. And we thank you so much for being here because it's because of you, attendees, that we continue to have this event and you make it successful every year. So with that, let's get into, or Jana, would you like to comment on our 7 years before I get into housekeeping?
Yeah, very quickly. Yes, absolutely. So thanks to obviously the presenters for the excellent content. Thanks to the attendees. And thanks very much to you, Angie, personally, because this has been a great collaboration between you and I to make this happen every year. And also to all the folks at PYA who are our teammates in these events, as well as our blog and podcasts that we do together. So thanks to everybody. Very exciting for the 7th year. Very cool.
Very good. So let's talk about housekeeping. So slides and handouts and forms are available in the resources panel. So what is the resources panel on your screen? It's the one that looks like the little cloud on your screen. So if you click there, that's where you'll find slides and handouts. You may enter questions at any time for our presenters. If they have a chance, they will answer them during the presentation. If not, they will follow up with you after in the Q&A panel. That's the one that has the little question mark on it, and you may submit questions there. You can enlarge the panels, move them around, get super comfortable, because this is your individual view as an attendee. So please size everything as you see fit. And if you run into any technical difficulties, please know step 1 is to refresh your browser. So now let's talk about CPE credit. So PYA is offering CPE and CHC credit today. For our CPE attendees, you must be logged in for the entire duration of the session and answer all 3 polling questions on the screen. After you have successfully met all of these requirements, you're going to see a little window where you will be able to immediately download your CPE certificate. It is awesome. You'll also get another CPE certificate link by email. CHC credit, we're applying for that. It'll take about 6 to 8 weeks following the event to receive that information regarding your credit. And then I'm going to allow Jana to talk about CLE credit, but also please complete the CEU survey at the end of the presentation today. That would help us greatly, and that will be located on your webinar dashboard. So Jana, tell us about CLE credit.
Will do. So for us lawyers, Foley and Lardner is offering CLE credit, and to be awarded CLE credit, you have to be logged into the session for the entire duration of the program. You must record the 5-digit CLE code that will be on screen later on the attorney affirmation form in the resources panel. So you have to sign and return that form after the session to LSHC events at lshcevents@foley.com. CLE credits are going to take a little while, so 8 to 12 weeks to process, so don't be panicked if you don't get them in a few days. So with that, our second session is going to be led by PYA's Barry Mathis and Foley and Lardner's Jennifer Hennessy, covering the trends in healthcare privacy and security, cybersecurity, patient rights, and reproductive rights. And now we're going to turn it over to our fantastic presenters. Take it away.
Thank you, Jana. As Jana mentioned, I'm Jennifer Hennessy. I am a partner with Foley and Lardner in our Madison, Wisconsin office. And I really spend all day, every day advising companies on data privacy and cybersecurity, largely in the healthcare space. So HIPAA, state law compliance, and everything that goes along with it. I'm very excited to be joined by Barry here today. We have done this presentation together for many years now, and we look forward to it every year. Barry, if you want to go ahead and introduce yourself as well.
Yeah, this is Jennifer and I's reunion annually. Barry Mathis, I am a principal among wonderful people at PYA. I have several subject matter areas that I work in on an annual basis. Been doing this about 30 years. This one is always dear to my heart. It's kind of where I got started, 30 plus years ago. And we hope to bring to you some very practical advice. We understand that there's a lot of noise going on right now in this space with some updated rules. But what we want to do is bring to you some things that you can actually work on right now and understand the environment, the changes that are going on. This is the year, in my opinion. 2025 is the year for some HIPAA changes and responsibilities. And we know you guys are building plans right now, so we hope that we can share something with you today that would assist you in doing so. Jennifer, back to you.
Thanks, Barry. Jana already gave us a nice little preview of what Barry and I are going to talk about today, so I am not going to go through this agenda slide in detail because, as you'll find out, if you've joined us before, Barry and I always have a lot of content that we try to cover, and we try to get through as much as we can as quickly as possible. Some of the things we're going to talk about today, particularly in my section, I'm going to say are a little bit to be determined under the new administration, and we'll talk about that. But one of the things that was taken very seriously by the first Trump administration and then also by the Biden administration, and then we expect the second Trump administration to take it very seriously as well, is an individual's right to access their own protected health information under HIPAA. And so we're going to start out by talking about that again today, because as I'll talk about, there have been 52 enforcement actions under HIPAA in the past couple of years just for this HIPAA right of access alone. And that's really the sole area where we have seen the absolute most focus by HHS in the past couple of years. So I think always a refresher on what is required under HIPAA's right of access is very important for organizations to understand. So the HIPAA right of access is that individuals have a very broad right to inspect and or obtain a copy of their protected health information that is maintained in a quote unquote designated record set. The designated record set is very broad. It is the medical record, it is the billing record, and is any other record used to make a decision about an individual. And I emphasize that because sometimes organizations think it's just the medical record, and that if something isn't in the medical record, the individual doesn't have a right to get a copy of it. And so I just like to remind organizations that it is technically broader than just the medical record. Covered entities have to respond within 30 days of getting that request. And importantly, HHS and guidance has said that that 30 days should be considered an outer limit. And in fact, they think organizations should have the ability to respond very, very quickly, given that information is obtained or maintained electronically in most cases. Of course, if you're the organization having to, deal with these multiple requests and actually respond to them, you might disagree that you can do that instantaneously, as the government might think that you should. But just to keep in mind that 30 days is the outer limit, and the government does expect for it to be done quite quickly. Individuals, again, get all PHI in the designated record set if they make that broad request, and they do get access in the form and format requested. So if the individual wants a paper copy, they in general should get a paper copy. If they more commonly want an electronic copy, they should get it in an electronic copy. And so it's important that you don't try to just give it in whatever form or format is convenient to you as an organization, because individuals do have the right to get it in the form and format that they requested in for the most part. And They have that right for as long as the information is maintained by you as an organization in the designated record set, regardless of when it was created, regardless if you are the organization that initially created that information. Of course, a lot of information comes over from other healthcare organizations and ends up in your electronic medical record. But if it's now in your designated record set and you get the individual request, you need to give the individual access to all of that information. There are very specific limitations on fees that we won't get into today, but keeping in mind, if you are still one of the organizations charging fees to individuals getting a copy of their own record, you want to be very careful that those fees are within the permitted parameters. And the other part of that right is that it's not only the individual themselves can get a copy, they can also direct you to send it to a third party. So part of that access right is that the individual can direct it not to just come to themselves, but they can direct it to go over to a third party. So as I alluded to, I always like to spend a little bit of a time in any presentation like this that I do reminding organizations about this, because this is something where we have seen HHS actually heavily enforce this. And so it's not just something they warn about, they are actively going after organizations that are not complying with this. So early 2019, again, that was the first Trump administration, HHS released a statement promising to vigorously enforce this right. And since that time, we have had, it's now at 52 right of access investigations. And again, that has spanned multiple administrations. So that isn't going to be the type of law that we think there isn't going to be as much attention to now. I would fully expect this right to continue to be heavily enforced. Potentially even more so going forward, since HHS thinks all organizations should understand this right now. And this slide here is just to, kind of flag that it's not just large healthcare systems that are getting these settlements. We've seen it with smaller dentist office, we've seen it with small mental health care providers, and then we've seen it with larger healthcare systems. So it's really been across the board, and the settlements have ranged from a couple $1,000s to up to $240,000. So quite a large monetary fine, in addition to what is even more painful in a lot of cases is the 2-year corrective action plan, where HHS keeps a very close eye on the organization to make sure they are complying with HIPAA on a go-forward basis. Turning now to an area where there is a bit of a to be determined as to what's going to happen with it. So as most of you are probably aware, early in 2024, HIPAA was amended to add in additional protections for reproductive health care information. And what those amendments required is that PHI cannot be used or disclosed to conduct a criminal, civil, or administrative investigation into any person for seeking, obtaining, providing, or facilitating reproductive health care, or to impose liability on a person solely for seeking, obtaining, providing, or facilitating reproductive health care, or to identify any person for any of those purposes. So again, it was the post the Dobbs decision, these amendments to HIPAA to try to provide some additional protections for reproductive health care information. Those are officially in the law. So again, it was passed in early 2024. It is officially part of HIPAA, so it's not something that's pending. This is the federal law right now. What's going to be interesting about it is, what's going to happen on a go-forward basis. But because this is part of the federal law right now, I want to make sure organizations understand what is actually required. And so the prohibition applies where the person is seeking, obtaining, or providing or facilitating reproductive health care, and the entity determined that it was lawful or otherwise protected by law. HIPAA also says that it's presumed to be lawful unless the entity has knowledge that it wasn't lawful, essentially. There's a presumption that any reproductive health care that was obtained is lawful in the way that HIPAA is currently written. Reproductive health care is really defined to be as broad as it could possibly be defined, and it means health care that affects the health of an individual in all matters relating to the reproductive health care system and its functions or processes. So I was just reading that out loud to you a little bit more than I like to, but the key is reproductive health care is defined very broadly. there are prohibitions in the federal law HIPAA right now about using or disclosing PHI for those prohibited purposes, which many healthcare organizations likely wouldn't be doing anyway. I'm just getting the slides back where we need to go here. There we go. Where I see there to be the more likely piece that is going to actually come into play for organizations, and in fact, you might already be seeing this at your organization, is this attestation requirement. So in addition to everything else we just talked about, if an organization gets a request for information that might include reproductive healthcare information, and that information would be disclosed to a health oversight agency, law enforcement, coroners or medical examiners, or in judicial or administrative proceedings, so think subpoena, court order, then the covered entity actually has to get an attestation before that information is disclosed that the recipient is not going to use it for those prohibited activities, and the individual has to actually sign it. HHS has provided a model attestation, so no one's having to create their own at this point. But if you think about how broad that requirement is right now, given how broad the definition of reproductive health care is, really anytime a covered entity is getting a request from one of those types of organizations or a subpoena or court order for, in particular, a woman's healthcare information, that covered entity needs to be really careful that it either does not contain anything that could be considered reproductive healthcare information, or what we've seen some organizations do is really just require the attestation anytime information would be disclosed to any of those types of recipients, because of how broad reproductive healthcare information is and the difficulty of parsing through an EMR record that might be disclosed to figure out if anything's in there. So this is a very far-reaching requirement that is going to require organizations to change their policies and procedures, make sure their medical record staff is trained up on this requirement and knows that, at least right now, this federal law does have this an additional attestation requirement before the information can be disclosed. In particular, again, subpoenas, thinking about how many subpoenas or court orders a typical healthcare organization tends to get. This is certainly something that is going to come into play for almost every single HIPAA covered entity. So again, what should you do? Make sure your staff are trained, make sure you have policies and procedures to follow these requirements that are in HIPAA right now. With me saying right now, because under the new Trump administration, it is to be determined what's going to happen with these laws. Again, this is a federal law right now, but there are two lawsuits pending in Texas. They've been pending for a couple months now. One is the state of Texas versus the federal government's Health and Human Services Administration. And then one is a private physician named Pearl, also suing the Department of Health and Human Services. So it's largely thought that probably HHS under the Trump administration might not defend these lawsuits, and that they're then potentially that would lead the court to rule that these amendments to HIPAA were overstepping, didn't take the right administrative procedures to have HIPAA amended in this way, and potentially they would be removed from HIPAA if the HHS did not defend the lawsuits. If that doesn't actually happen, it's also entirely possible that the Trump administration would not actually enforce this part of HIPAA. So even if it remains in the law, remains part of federal law, the Trump administration or HHS could actually issue a statement saying that they're not going to enforce this part of HIPAA. So again, it is federal law right now. I don't want you to think you shouldn't be following it, which is why we wanted to touch on it, but it is going to be important to see where this goes in the next couple weeks or months, probably. And I will pause there and let Jana read the polling question.
Okay, great. So for the first polling question, when a HIPAA regulated entity receives a subpoena for reproductive healthcare information, it should, 1, follow HIPAA's requirements for obtaining an attestation from the requester prior to disclosing the information. 2, disclose the information to the requester. HIPAA's reproductive health information amendments are no longer part of the law under the Trump administration. disclose the information to the requester, you have to comply with the subpoena. Sorry, I was slightly out of order with my responses. Apologies, but please do read on screen, please respond, and remember that for CPE credits, you have to be logged in for the entire session, and you also have to answer the 3 polling questions. And for us CLE and CHC folks, please just respond because we are interested in your responses. So with that, I'll leave it to you, Jennifer and Barry.
Yeah, thanks for all your responses. So the correct answer is, as of right now, follow HIPAA's requirements for obtaining an attestation from the requester prior to disclosing the information. The vast majority of you got that, so I think I came through pretty clear on that part of the presentation, which is great, and thanks again for participating in that poll. What we're going to turn to next, and really what is kind of the outlying theme for the rest of this presentation when Barry takes over as well, is trends in healthcare cybersecurity. It's been an exciting time, I would say, in healthcare cybersecurity over the past year. HHS had been, kind of whispering about updates to the HIPAA Security Rule, I guess is a good way to say it, for a while. And on January 6th of this year, so just a few weeks ago, we actually got the proposed updates to the HIPAA Security Rule published in the Federal Register. And they really are proposing to, significantly strengthen the requirements under the HIPAA Security Rule. The HIPAA Security Rule was drafted in 2003 and really had not been substantially updated since that time. There were minor updates to pull the business associates into the HIPAA Security Rule in 2013, but that did not actually change the security rule requirements. So again, we're talking about, 2 decades ago, and think about how much security has changed since that time. I think most people think that updates to the security rule were certainly needed, but whether it's going too far is something that Barry and I will talk about a bit. Certainly healthcare organizations and certainly large or sophisticated healthcare organizations have for years been using other types of frameworks as their cybersecurity framework, as opposed to using the HIPAA security rule, because it really was a floor or a real low standard for a cybersecurity, program. So the NIST cybersecurity framework, ISO, SOC 2, high trust, those types of frameworks are certainly where a lot of healthcare organizations were looking, as opposed to using the HIPAA security rule. Comments to the proposed rule were due March 7th, although there is now a regulatory freeze under the new Trump administration, so that timeframe will be pushed out. And I know Barry's going to talk more about that too in his section. So those comments are not going to be due by March 7th. There will be additional time to go through those and provide some detailed comments for organizations that are looking to do that. And it's unclear, again, how the Trump administration will view these proposed updates. Although I will say in the first Trump administration, they were quite focused on cybersecurity. So it'll be an interesting interplay between the focus on cybersecurity that we know the Trump administration has historically been interested in, but their trend of preferring less regulation. So those two things will be interesting to see how they play out here when it comes to these proposed updates to the security rule. There are a lot of substantial updates to the security rule, as I said, and so just going through some of them here. Eliminating the required versus addressable implementation specifications. So any of you that have spent much time with the security rule know that it's currently drafted where there are things that are required, then there are things that are addressable, but HHS has always told us addressable does not mean optional. And so it was really quite confusing for organizations to know what to do with these quote unquote addressable implementation specifications, which included things like encryption. So that's totally being eliminated under the proposed rule, where everything is just going to be required. That would be in the security rule going forward if it goes forward as currently proposed. It also would require a written inventory of technology assets and a written network map there's going to be more specificity on the risk analysis. So right now, the risk analysis requirement under the security rule is very short. And most of the detail is actually provided in guidance documents and various other pieces of literature that HHS has put out over the last 20 years. It looks like they're trying to take a lot of that guidance and actually stick it in the security rule itself to make there be a lot more detail on that security risk analysis, which is important. Not to skip to my next slide before I get there, but HHS has warned for years that they know organizations are not performing a security risk analysis in the way that they expect them to be doing under HIPAA. And so we have actually seen in the past couple months, HHS announced a security risk analysis enforcement initiative, just like that right to access initiative that I mentioned earlier. And there have been just a couple in the past month or two actual enforcement actions and settlements with organizations under that security risk analysis enforcement initiative. So we do know that HHS is going to be paying particular attention to that. And so it's always been important for organizations to have an up-to-date and thorough risk analysis, but it's going to be even more important going forward under that initiative that we have now. The proposals would also expand the technical safeguards, for example, requiring encryption, requiring multi-factor authentication, very few exceptions for either encryption or multi-factor authentication, require patch management, network segmentation, configuration management, disabling network ports, penetration testing, all things that many organizations are already doing if they're following best practices from a cybersecurity perspective, but it wasn't necessarily a violation of federal law to not be doing those things and doing them in particular timeframes as well. I mean, as the security rule is currently proposed, there are going to be a lot of specific timeframes for when things need to be happening under as well. And then in addition to all these safeguards that would need to be brought into place, all the business associate agreements in place would need to be updated as well, which is, those of you that had to do it back in 2013, quite a big list to go through and update every BAA you have in place. Business associates are going to need to notify covered entities when they activate their contingency plan. And then covered entities also have to annually obtain from their business associates a written analysis and certification that the business associates are complying with all these technical safeguards. And those requirements are going to have to be added in to the BAAs. And that's really just skimming the surface of what these proposals have in them. But as you can tell, I mean, it's quite a change from the pretty baseline requirements that we have in place right now. This is just what I was mentioning before about the security risk analysis enforcement initiative. So I won't go into that again, just in the interest of time, but just keeping in mind, very important to make sure your organization has that up-to-date and thorough security risk analysis. And pivoting off of that, the reason that we're seeing an increased, examination of the security provisions and the cybersecurity posture of healthcare organizations is largely due to the rise in ransomware attacks in the healthcare sector. So since 2018, there's been a 264% increase in large breaches reported to OCR that involved ransomware attacks. So just an exponential increase there. And then OCR has actually settled multiple ransomware investigations in recent months. So I believe that they've settled, I think, 5 or 6 ransomware investigations just in the past couple months alone. So these have been reported, with increasing frequency to OCR. They've been investigating them over the past couple years. As you know, those investigations often take a couple years. And we're really starting to see those enforcement actions come rolling out in the past couple months. And we've seen penalties ranging from $90,000 up to a pretty substantial $950,000 so far. And in most of those settlements, we're seeing OCR really point to the lack of the organization to have a compliant risk analysis in place. So there was a failure to identify risks and vulnerabilities that ultimately potentially led to the ransomware attack affecting a lot of patient data. I will now turn to our second polling question.
Terrific. Poll question number 2. In HHS resolution agreements entered into between HHS and HIPAA regulated entities subsequent to a HIPAA breach, the most commonly listed violation is failure to train employees, lack of notice of privacy practices, or failure to conduct an accurate and thorough security risk analysis. We're going to leave this up for a few seconds here and allow folks to respond. Please remember, CP participants, this is poll question number 2. You need to answer all 3 polls and stay online the entirety of the presentation to receive CPE credit. CHC and CLE participants, you need to attend the entire time, but you don't have to answer the poll questions if you don't want to, but we would love to hear from you. Please respond and participate in the polls. It helps us to know what you're thinking out there. So we're going to give folks just another second. Participant numbers are still rising. Okay, back to the presenters.
Awesome. Yeah, again, most of you got this one. In almost every data breach settlement we see with HHS OCR, we see them point to a lack of an accurate and thorough security risk analysis. So it really is a common theme. And again, very likely why they're rolling out that enforcement initiative to try to make it even more clear that they expect organizations to be doing these on a regular basis. Thank you so much. I'm going to turn it over to Barry now, who's going to continue to talk about some cybersecurity trends and things you should be keeping in mind.
Thank you, Jennifer. So we're going to go into some effective strategies on cyber event responses, and then we'll pepper in there a little bit of AI and how that's working its way into the industry as well, both from a positive defense as well as a negative from the persistent bad actors that are out there. Before we jump straight in, I want to add a comment into around the public rule in the open comment section. There should have been, and I think Matthew put that in there. Thank you, Matthew Lennon, our presentation engineer, a link to the public comments. And I want to encourage you. One, we thank our legislators, our architects, our authors. We've been waiting for this for quite some time. We've appreciated the guidance and it's been helpful, but having it written into the rule so that it's defensible and arguable is important when we get in these situations. So having said that, I do encourage you to comment both positive and or any pushback if there are challenges that you're going to experience. And if you're an organization, and I see several, I see friends out here, I'm looking at the attendees and I see some of these wonderful health systems and their compliance officers. Gather some folks together, get those comments, talk to your IT folks. For example, pose a question on, do we need clarity on data at rest encryption? Can Epic ever really be at rest? Can Cerner ever really be at rest? So those kind of things, and put your comments together and respond. I don't just think it's an opportunity. I think it's a responsibility from an industry that we give our legislators, authors, and architects some type of feedback for that. So beyond that, there was a comment in there around the way the rules, the risk analysis may be changing. So one of the things I would encourage you to do, and I'm doing this up front because I know some of us are multitaskers and I want to get this in there because these are some good nuggets for you. Take a look at what you've been doing, right? So once the rule is final and there's some clear guidance in there, if you, for example, if you have a breach response, and most of you have gone through, a lot of you have gone through this, and there's an investigation, they don't ask for last year's risk analysis report. They ask several years. I've seen 6 and I've seen 7. The most common is around 6. Document what you've done in the past and how it is impacted by the final rule. And if there's gaps there, admit it. We've been doing it this way. Here's the gaps. We've changed it. Document your changes and then proceed forward with your new plan for what your report's going to look like. I'm hoping in the comments we can get some additional details and maybe some templates and some examples, but in either event, document what you're doing with those changes. Here's the last thing I'll tell you, great golden nugget for you. Get your team together, small at first and it'll grow, and ask yourself this question. If we had a cyber event, you decide what event is, but it resulted in an investigation or a civil matter, because that's an option in some states, could we, without saying a word, defend our decisions and show that we are protecting the data in accordance with current and future rules? What do we need to close the gap on? And it's important that it's done without verbiage. right? Because if you can't upload the evidence to the portal that you're going to be given a link to for what's called a desk audit, chances are you're not going to do well in the audit itself. So those are some tips right up front. Let's move into some of the other cool stuff. So develop a response plan, like anything, and with planning, getting the right people involved, making sure it's comprehensive, ensure that the roles and responsibilities, communication protocols, there's a lot of things in there, and there's tons of information, and I mean beyond, hey, chat GPT, how do I do this, right? There's a lot of information in thought leadership and publications. We've offered some, I know Foley's got some, and others that will help you decide what that looks like. What does that plan look like? Most of you at this age or at this stage have some type of a plan, okay? I had a brigadier general when I was in the Marine Corps pull me aside with a team one time in a prep for a mission that basically said, listen, polished, when steel, hardened steel and soft metal are both polished, they look the same. It's only when you take them into battle that you find out which one is worthy to hold. So take your plan and put it through some testing, training, simulations. Find out, is it soft metal that may not hold up, or is it hardened steel that put against scrutiny will actually hold up? Detection and analysis, monitoring systems. And we're going to talk about the AI. Right now, it's just a matter of advanced monitoring systems. One of the things that's really cool about my job, and there are several, but one of the things that I think is really cool is I hang out a bit in the dark web. I converse with bad actors. I read forums. I see comments. I see tools. I see the broker pages where your data that's gone missing is sold. Let me tell you about a trend that's happening in the dark web where people who are exploring. It's like anything else, a dark alley with flashing lights. There are certain people who will turn away and go. There are certain people who will turn down and look. For those people who turn down that alley and look, here's what they're finding. Bad actors are educating employees, right? Now, it's not limited to healthcare, but they are educating employees. If you don't want to make some money, there's two ways. One is to work with a system like Lockbit, download the software, load it, ransom it, will give you a percentage. However, most people, even those whose scruples are fallen by the wayside, would say, I'm going to get caught doing that. It's not worth it. Could be worth $1 million, but it's just not there. And the bad actors have figured that out because they're slowing down in some of those, right? The other franchises are saying, look, the way to do it and not get caught is take a little at a time. So if you're an employee and you want to make some money, and in most cases you're disgruntled, take a little bit of data at a time, save it up over 6 months, and then sell it on the dark web. You get good money for it. Sounds kind of scary. It is, but it's real. How do you detect those little bitty pieces? So one of the things, and we'll talk about how AI can help, but your monitoring is not always just monitoring email and looking for someone who is exfiltrating large pieces. You should be looking at things that simply aren't normal. Barry works in housekeeping. Why is he even accessing this server and pulling off even one record, right? Doesn't make any sense. Barry works in IT. He has access to all this, but why is he over here on this server? You look at the environment. So that's what's going on in the dark web. Analyze the incidents, okay? Make informed decisions on how to respond to future incidents. These are just little tips going along. Containment, eradication, and recovery. This is pretty basic. We've preached this for quite some time. Containing the incident, and I've seen everything from, I had a client who said, look, we had a near miss. We knew we had a bad actor in. I said, well, how did you contain the incident? He said, we unplugged the network. Are you okay? Disruptive, but effective. It works. But there should be something in your plan that says, how are you going to contain it? There should be people with responsibilities for limiting access that know their role. I describe incident response plans like a binder, a 3-ring, 4-ring, 5-ring binder, and you open it up and there's colored tabs. If I'm IT, I go to my tab and I start working my plan. If I'm public relations, I go to my tab, I start working my plan. No matter who I am, if I have a spot in that plan, I turn to my tab and I start working that plan. That's good communication across. If you're doing something different than that, you run the risk of cross-talking and making it worse than it has to be. Make sure your plan is clear. Eradicate the root cause. That's usually the IT folks that's on their tab. Recover the systems. That's usually on the IT tab. Okay. One of the tips that I'll give you as an old IT guy, if you're storing your stuff on your laptop and your laptop gets infected and encrypted, then it's not, your data's gone. So as much as you want it local, likely the IT team within your organization has contingencies around backing up the cloud or backing up their servers. Put your data there, not necessarily on your local device. Public service announcement from an old bald-headed IT guy. I will give you a little, I recently, I won't say what state, even though the CEO was a public announcement, we presented a case study where they had a ransomware, and myself, the CEO, and the insurance company that worked the ransom event, we were all on stage talking about step by step. I kind of facilitated. And towards the end, I asked the CEO, you know, what's the biggest mistake that you think you guys made? He said, it's going to sound silly, but we had our plan on a server that was encrypted. Nobody thought to make a paper copy and put it somewhere. Make a paper copy and put it somewhere. Secondly, I said, well, when you started to recover your systems, did you discover anything? He said, well, technically we had about 4/5 of it done within a month, but they didn't drop a bill for 66 days, I think, but they had cash on hand. But the thing that troubled them the most was they didn't understand the underpinning technologies for recovery. For example, their PAX system didn't come up for almost 4 months because what they didn't realize, the vendor couldn't overlay the backup on the current old system that they restored from their system restore. They weren't synced. So they had to go back years, restore that one, update the patches, restore the next one, update the patches, restore the next one, update the patches, and finally put down the current data. And it took them quite a while. Understand what that looks like as you start to discover what your recovery looks like. So AI, I love AI and I hate AI. Okay. It's that duality that we're dealing with. But when it comes to cybersecurity, on the positive side, there are amazing threat detections that are out there. Now, not everything's AI, and I encourage you, before you sign up a subscription with a vendor, you do some due diligence, hire somebody like Foley or PYA, others that know the industry, that know these players, and can give you a sense of, is this going to do what it says it's going to do? Not this one because it's only $29.99, okay? There's a lot of out there that say they do it, that they don't. But true AI threat detection, okay, some of this is proprietary, used by third parties. Some of it's off the shelf. You can purchase it, put it in. It looks for the environment. It doesn't necessarily link itself to the user. Take an EMR software, and I'm not going to mention names. We don't necessarily promote products, but you all can pick out the one you have that does your audit for your users' access to your EMR, right? They are kind of tied to that user. What is that user doing? These AI enhanced threat detection tools, they're tied to what's going on in the environment. They don't know who the user is. What they know is a processor on a device with an address, not an IP address, but a hardware address, is doing the following on the network, and it doesn't seem normal, right? So it stops it, sends IT or whomever the administrator is a notice and says, you may want to take a look at this. And it does that. It cuts off the bad that's happening. So maybe it contains the infection to a smaller piece and doesn't impact the entire organization. So automated incident response, that's what that's about. That's what it's doing. Without having somebody to say, hey, I see something and I stop it, AI is now taking the place of saying, hey, look, as a software, this doesn't make sense. I'm going to stop it. You decide if it's right or if it's wrong. And then predictive analysis, using AI to predict potential threats and base. AI is great to take a map of everything that's going on in your configuration and then run scenarios and try to find a weakness. It's like pouring water into a bucket, a large bucket, to see if tiny pinholes are leaking. So predictive analysis with AI is amazing. I love it. It's one of the things that I like the most about AI. Before we go into additional tips, I'll tell you what I hate about it. The bad actors have their versions too. The bad actors, which were limited at some point to people who had been in the industry for a while, really knew what they were doing, could write very clandestine code to do this. Now they can go out to things like Fraud GPT, Chat GPT, and say, I need a piece of code that does this, that I can launch in an email for an Exchange server in a 365 cloud. They hit a button, 8 seconds later, they've got the code. They don't have to be experts. They can just be interested in doing bad things, and all of a sudden they're in a clandestine industry. So additional tips, collaboration and communication. I'm not going to spend a lot of time on this. Again, this is all about your plan, but make sure you're including all the stakeholders. Okay, this includes, and we're going to talk about second or two-party vendor, third-party vendors. Make sure everybody's included. It's not an IT thing. It's not a clinical thing. It's not a financial thing. It's not a compliance thing. It is an organizational thing. Make sure everybody has a seat at that table. I'll promise you're going to find some things that you didn't believe was a risk that are going to be part of your plan to mitigate. Continuous improvement. If you've been in compliance as long as I have, you know that this is the secret to success. It's not something you can touch every day. I went out and read some of the comments that are already out there in the proposed HIPAA security rules. One of them that I loved was in the rule right now, it talks about doing vulnerability testing annually. And they were getting already kind of lambasted annually. We were doing annually 10 years ago. It needs to be weekly, monthly. And I agree, continuous monitoring and improvement. Compliance and reporting, I think Jennifer's already touched base on that. I'm not going to go to more of that other than understand clearly what it is, or find yourself a Jennifer who clearly understands what it is and make sure she's part of your response team. Okay. There you go. Advance. Okay. Managing cyber risk with third parties. So that's kind of some tips and things around, what's going on. Managing in third parties. Third parties pose a big risk to organizations when it comes to cybersecurity. And one of the things that I'll tell you is every one of them, when you sign the contract, if you read, it's going to have some pretty thick indemnification and protection clauses. So if the place burns down, the soot doesn't get on them. However, I'm not a lawyer, right? You need to have one with you when you're working through these, because likely it's not going to cover. So even if the third party sends you a letter that says that was not our fault, do not take that. Get your attorneys involved. If you don't have inside counsel, call Jennifer. And because you're going to find out a lot of that stuff doesn't cover negligence. They can't just do whatever they want. And I've seen people by the wayside simply accept the vendor's comment that was your responsibility. No. Third parties, they are culpable in a lot of cases, whether they realize it or not, but they do pose a big risk. So what do you do? When you start to engage with that third party, do some diligence. Don't just lemmings along with everybody else at what they're doing, because there are some that have made skyrocket success and they really shouldn't have, okay? Because they have a good tool, they have a good presentation, a good marketing, but when you get right down to it, it's no more effective in some cases than what you were doing manually. And it's not even truly AI, okay? Do the diligence. Make sure that you do a risk analysis or require, and again, the new proposed rule has some of this in there, right? Which is one of my comments back to them is, can you get very specific on what we can and cannot accept from some of these third parties for a risk assessment? But do your diligence around that third party before you give them access to even protecting your data. Establish security. Make sure you clearly define, okay, in the contract what it is they're supposed to be doing. And a good way to do that is reference the nomenclature that you're both required to do, especially in a PAA, right? Don't make up something that already exists. It's already passed law. Put it in there. If there's guidance that's out there, you heard Jennifer mention earlier, we've not had any true law changes. We've not had any rule changes in quite a while. But HHS was very busy when guys like me and others were simply complaining about, can you please tell us what you expect when our clients have this issue? Because I talked to an auditor from OCR in this state, an auditor from OCR in this state, and they're not even together. Let us know. So they would put out guidance. You should do your risk analysis at least in compliance with this special publication 800-30. Well, that was helpful. Now we have something to do. So make sure your security requirements are defined, or at least reference those that are guidance. And then again, right back to continuous monitoring. It also applies to those third-party vendors. If you don't have somebody, or if you don't have a team, third-party vendors that are managing your data, touching your data, and even those that are there to protect your data, if you are not standing around or standing, I won't say standing over, maybe that's too aggressive, but if you're not at least monitoring what the expected versus what your outcomes are, I'll give you an example. We don't name names, but a third-party vendor for a client out in a beautiful part of the United States where there's mountains, okay? They trusted this vendor for years to protect and provide a report. When they actually had a breach and that's investigated, none of that held. It was all soft metal, none of it hardened steel. They had not done their due diligence. They had not checked references. They simply said, everybody else in town is using these folks. We think they're great. They had a great marketing. None of that held up. And they had a breach. And now they're having to answer to OCR, hey, what did you do to make sure this vendor was doing what they're supposed to? There was no continuous monitoring whatsoever. So make sure you've got that continuous monitoring in there. Time check, I got 10 minutes and I got to move on. All right, good deal. Establish security requirements. We did that already. I was on there. Polling question number 3. We're towards the end. Or did I skip one? I think I got them all.
No, you're good.
Okay.
We're good.
Polling question number 3. Go ahead.
Yep. And if you can advance the slide, it's what is the single most important element of effectively responding to a cyber incident? Number 1, ensure you have a cyber insurance policy. Number 2, ensure you have communicated to all third-party vendors regarding the incident. Number 3, ensure you post clear communication on social media about the incident. Number 4, ensure you have a well-vetted and practiced response plan that includes all stakeholders. And number 5, ensure you have a highly trained technical forensic staff employed to handle the incident. So again, for those seeking CPE credits, you have to be logged in for the entire presentation and answer all the polling questions. This is your third and final one. If you're seeking CHC or CLE, we would love to get your input, and we'll wait for a minute to see if we can get a few more folks responding, and then we will push the results to you guys so you can see them, and Jennifer and Barry will react to them. To give it just a few more seconds.
Here, I'm counting, trying to figure out percentage wise. So we've about got in. Most of you got it. Granted, all of these things are good things to do. Maybe -1. And the reason I put it out there because it's an actual example where somebody thought they were doing a good thing to let everybody in town know that this was an accident. We're so sorry, and it's out there on their social media. And it didn't come from an employee. It came from somebody in charge. Leave social media alone, okay? But absolutely have a plan. All of these things could be in a plan. You could put in your plan, make sure you have cyber insurance. Absolutely needs to be in the plan. You can put in the plan clear communication. You saw me talk about that. Absolutely in the plan. Ensure you have highly trained technical forensic employees to handle the incident, or you hire somebody. That's in the plan. So let's talk real quickly. Got just a couple of minutes. I want to fill a little time here. Some actual examples and things around responding to an incident. Again, so here we are at the end. You've done your polling questions. Some of you are moving on. Some of you are staying. For those of you staying, thank you very much. I'm going to give you some stuff right here at the end. Number 1, if you have, okay, or when you have, let me change that. When you have some type of cyber event, ransomware, other, in your plan, tab number 1, across all the other tabs, do nothing until legal and compliance say. Just sit, okay? I can give you an example of where I consulted after the fact with someone who really felt like they had it handled. They had inside expertise, and they went ahead and reported that they had had a breach, only to find out once the insurance company and the bodies and the forensic team got in there, they had an infiltration. Somebody did get access to the system, but in reality, what they thought had actually exfiltrated and breached never was, and they were able to prove that. So they reported they didn't have to, right? So don't do anything until legal and compliance, or whomever you've defined. Sometimes it's 3 or 4 people that includes legal and compliance. It should always include legal and compliance before they say move. Don't say the word breach. Don't even say the word event. I like to use cyber curiosity. We have a cyber curiosity happening in our organization. We'd like to explore it. Once that team gets involved, then they will dictate what the next steps are. Somebody on that team should be designated, a single body and maybe a proxy, to say we have what we consider, based on what we've seen so far, a cyber event of some kind. We now need for everybody to start doing these things, okay? The other thing I'll tell you is, as an individual, and this is something that you should put in your cyber education, okay? Your security, your periodic or your main, either one. And that is the old adage that we get from TSA and everybody else. If you see something, say something, okay? Because here's an example where there was a person. Now, it was a near miss. Nothing happened, but it could have. They were at their computer, And all of a sudden, their screen started moving around, the arrows moving around. And they're like, well, that's crazy. That don't make any sense. And they started making phone calls. What's this happening? Who's this? Eventually, 20 minutes later, they finally got a hold of IT. And IT said, oh, sorry, it was this other person I was trying to update. This is our tool that we use to connect to your computer to do these changes. That's all it is. So that was innocent. But here was my commentary behind it. What if it hadn't been? So your education should say, if you see something, if you're sitting here working and your arrow starts flying across the screen, turn the computer off, shut it down, pick up the phone and call IT and say, let me explain. The worst that can happen is IT is going to say, yeah, you just cut me off. I was trying to help you. Okay, sorry, I'll restart it. You should have told me ahead of time. Do not sit and watch and try to figure it out. That's not what you're there for. Your employees should know that. Okay. So with that, Jennifer, is there anything else that you want to add as tips as we close out?
I don't think so, Barry. I feel like you so thoroughly covered, the important aspects of when someone suspects that we usually call it an event, but I like your cyber curiosity. But I share your thoughts of you don't want a bunch of people in your organization emailing or putting in writing that you have a data breach, which is a legal term in our world that likely has legal implications that involve notifying patients, other consumers, and potentially regulatory authorities if you don't actually have a breach. Because a lot of things that start out as a cyber curiosity or a cyber event may potentially end up just staying at that, or they may rise to the level of some type of incident, but they may not rise to being a breach as we define that under HIPAA or other federal laws or state laws. And so you don't want to have a bunch of documentation indicating that was the case in your system. And just like Barry, I tend to see that a lot, where we're then trying to have to add in documentation to the file explaining why we don't actually have a breach, although we have, weeks of documentation talking about a breach that we, don't actually think we have now. So just emphasizing that point, Barry, but otherwise I think you covered all the issues beautifully, as always.
Thank you, Jennifer.
Thank you for listening to this PYA webinar recast. The video recording, slides, and associated material for this and all PYA webinars are available on our website. If you have any questions or if we can help, please contact us at pyapc.com. Thank you again for joining us and have a great rest of your day.